you need to pay the prescribed fees for granting that particular patent rights. So it should be in cash, or it can be in the local check, or it can be through the demand draft. After it is been notified in the Gazette, if there is an opposition, then that kind of opposition must be filled within 4 months from the notification of the Gazette. The abstract of invention means what are the important inventions you have done, what are the abstract of it. So that important document has to be given in 3 copies. Hi and a warm welcome to you all dear students. I, George Elme, Commerce Faculty, Department of Commerce, Vidhyaashram First Grade College, MYSURU. Dear students, today we are going to take up session 4 for the unit 4, that is Intellectual Property Act. So in today's session, let us understand what are the procedures and what are the important documents required for the registration of this particular patent copy or the patent rights. The documents which is required for the filling of an application. First and foremost, it says application form should be in triplicate. Triplicate means three forms should be there. So you should submit 3 forms, right? Then provisional or complete specification in triplicate. So that application which you give, it should be a provisional and it should be complete specification. Everything has to be in detail. That is what it says. And in all the 3 copies, then if the provisional specification is filed, it must be followed by complete specification within 12 months and 15 months with extension. So whatever the provisional specification you are going to give, and that should be followed. So provisional means it is you get a provisional certificate in a degree after finishing a degree. So then later on you get a convocation certificate. So provisional means it is just a certificate, or it is where you are just giving the tentative, we say, tentative specifications or applications which is not fully filled up, okay, where all the details will not be given in that. But and it should be filled and followed by complete specification. Later on, that is within 12 months, that is from past within 1 year of whatever the provisional specification you are given. So that should be done within 12 months, right? And that is for 1 year and 15 months with extension. So later on, again, it can be extended for another 3 more months. So within 1 year, you should give the complete specification in triplicate copy to the in form of application for patent right, or in order to get the patent right. Then drawing in triplicate, if any drawing regarding that particular subject matter or that particular product, then that should be also given in the form of 3 copies. It should be in the 3 copies, okay, and if it is necessary only. Then abstract of the invention in triplicate. The abstract of invention means what are the important inventions you have done, what are the abstract of it. So that important document has to be given in 3 copies. That is also in 3 copies. Next, the information and undertaking listing. The information related to that particular patent rights or the the product, so or invention. So it should be in undertaking listing, that is the number, filling date, current status of each foreign patent application in duplicate. So here the application, it should be followed with the information, full information, and also the number, filling date, then current status of that particular each foreign patent application in duplicate. That should be submitted. Then priority document, if any priority date is claimed, then you should produce the priority document. Then declaration of inventorship, where provisional certification is followed by complete specification, or in case of convention application. So declaration of inventorship. So you need to declare that you are the inventor of that particular product or the item, and where it says provisional certification is followed by complete specification. So you need to give a complete specification followed by, already you are given a the provisional certification or the specification. Now along with that you need to give the complete specification, or it says in case of convention application. Then power of attorney. Power of attorney means the power of attorney where you are getting the rights. So it should be filed in the through the patent agent. So the power of attorney where you can get, or it should be granted, so that should be filed by the patent agent. And also the fees in cash, you need to pay the prescribed fees for granting that particular patent rights. So it should be in cash, or it can be in the local check, or it can be through the demand draft. Now, where this appropriate office is there for filing this application for getting the patent rights? So it says application is required to be filled according to the territorial limits where the applicants or the first mentioned applicant, that is in case of a joint applicants for the patents normally who resides or lives or as a domicile means the place where they are staying as a place of business or the place from where the invention actually originated. So here you need to put the application in an appropriate manner in the appropriate office, right? So it should be required, the application is required to fill according to the territorial limits, that is, which is where the applicant of the first mentioned, in case if joint applicants. So first and foremost it says the application should be filled and it should be submitted where the applicant is first mentioned, where he has mentioned, right? That is that particular applicant. And in case if there are joint applicants for that patents normally where they reside or the place of residing or the domicile, as well as, or if it's a place of business where it has been conducted, or the place from where that invention is been originated. So from any of this they need to apply in the appropriate office. Now if the applicant for the patent or the party in the proceeding having no business place or domicile in India, then the appropriate office will be according to the addresses of service in India given by the applicant or party in the proceeding. So if the applicant for the patents or the party in the proceeding having no business, so they are not having any kind of business, that is the person who has applied for the patent rights or the party who has proceeded for this application and who has put application to get the patent rights, and those who are not having the business or the place or any kind of domicile in India. So those kind of persons, what they have to do is they need to go to the appropriate office which will be according to the address of the service in India given by the applicant and or the party who is in the proceeding for application. Then all the applications for the patents accompanied by complete specification are examined substantively. So once everything submission of the application is over, then the appropriate office, one who gives or grants this particular rights to the patentee or the inventor, they will thoroughly check, they will go through the applications which is related to the patents rights. So and that patent application should be accompanied by complete specification regarding that particular subject matter of the patent rights, and that will be examined thoroughly, right? And at first the examination report of the stating of objections is communicated to the applicant or his agents. Now at the beginning, if there is any kind of opposition for this particular patent rights from any other opposite or third party, then that will be first communicated to the agent or to the applicant. Now the application of the complete specifications may be amended in order to meet their objections. So here the application or the complete specification related to the subject matter of patent rights may be amended, that is in order to meet any kind of objections. And it says normally all the objections, if any objection or the opposition comes in related to this particular subject matter of patent right, must be met within 15 months from the date of first examination report. So within the 15 months from the date of first examination report, this particular objection must be dealt with. Then extension of the time for the 3 months is also available for this objections. But whatever the case may be, the application for the extension therefore must be made before the expiry of the normal period of 15 months. So whatever the case may be, any objections may be there, but still anything, whatever the matter is, but still it says it should be made before the expiry of the 15 months, the period of 15 months. If all the objections are not compiled within the normal period or within the extended period, the application will be deemed to have been abandoned. So in case if there is some objection and that objection you are not given a proper reason or there is no solution for that, then if that particular objections are not compiled within that normal period of 15 months, right, then or within that extended period 12 months or 15 months, then that application will come to an end or it will be ceased or it will be abandoned. Then when the application is found to be suitable for acceptance, after all the clearance from the objection from the third party or for the opposite party who has given or opposed this, it says the application is found to be suitable for the acceptance. It has been published in the Gazette of India in part 3 section 2. So once the application is being accepted and suitable for acceptance, then that will be published in the official gazette, right, of India. That is according to part 3 of section 2. And this will be deemed laid open to the public on the date of publication in the Gazette of India. So surely this will surely have a very deemed laid open on the public, where on the date of publication the Gazette of India is accepted it and it has been published. Now opposition. What is the opposition? Notice of opposition must be filed within 4 months of the notification in the Gazette. So after it is been notified in the Gazette, if there is an opposition, then that kind of opposition must be filled within 4 months from the notification of the Gazette. So within 4 months, any opposition is that should be mentioned. Then extension of 1 month is available, but it must be applied or before the initial expiry of the initial 4-month period. So here the extension can be for 1 month is available. That is for putting the opposition. But it must be applied on or before the expiry of the initial 4 months period. Now granting or sealing of patent. Now under this, students, it says if the application is not opposed. So if there is no opposition or no one is opposing for the grant of license for the patent rights, then or the opposition is decided in favor of the applicant. In some cases, there will be a mutual concern and the opposition party will be agreeing and they'll be decided to favor the applicant who has applied for the patent right or is not refused, the patent is granted or sealed on the payment of sealing fee within 6 months from the date of advertisement. However, it is extendable by 3 more months. So in case if there is no opposition, as I told you, or if in case the opposition party has mutual concern and he has stopped or he has withdrawn his opposition, then in favor of the applicant, and it is not been refused, that is not refused the patent for granting or sealed on the payment of sealing fee within 6 months from the date of advertisement, then they can grant him the seal and the grant of patent rights can be done, and it is extendable by the 3 months. Now, register of the patents. The register of the patents will be kept in the patent office and at the branch offices. So, the register for the patents that will be kept in the patent office and its branch offices. The register of patents can be inspected or extracts can be taken or obtained on payment of prescribed fees. So, if anyone wants to see that, to look into the register of patents, which are the companies, which are the products is being patented, it is open to everyone, all to the public, and they can see it as well as they can inspect it, and also if they want an extract, a copy of it, they can do it so by paying the payment or the fees which is prescribed. Now, register of the patent contains all the full details about the patent regarding which includes patent number, then secondly the name and address of the patentee, one who has taken the patent rights, the notification of assignment on whom it has been transferred, the renewals when it has to be renewed, the particulars in respect of proprietorship of the patent. So, the ownership which has been granted as a proprietorship of the patent. So, all this will be regarding the grant or sealing of patent rights. Now, right of the patent. What are the rights of the patentee? So, once the patent grant is been given to the patentee, there is some exclusive right where it says to make the used patented article or use the patented process. So, he has every right to use that patented article which he has got the rights to use it, as well as on the patented process also. Now, he can prevent all others except him, he can prevent everyone, all others from using or making this patented process. And the patentee has also the right to assign the patent, that is, he can transfer this rights to another person or granting license under or otherwise deal it with for any consideration. In order to get something in return, there is a provision or the right on the patentee that he can assign the patent rights to another person so that something he gets, that is, he may grant license to in order to use that particular patents. So, these rights created by statute are circumstanced by various conditions and limitations. Now, coming to the renewal fees. Renewal fees are nothing but they are payable every year. So, once in a year you need to renew your patents which you have got the patent right. So, first renewal fees payable for the 3rd year of the patent life. So, if you have got in this year, that is in 2021, so in 24 you need to first do the first payment, that is the first renewal you have to do, paying the fees, and must be paid before the patent 2nd anniversary. So before the patent second anniversary, then you need to pay this amount or get the renewal of that particular patent. The patent has not been issued within that period, then the renewal fees may be accumulated and paid immediately after the patent is sealed, and or within 3 months of its recordal in the register of patents. And it says the date of payment of renewal fees is measured from the date of patent. 6 months grace is available with the extension fee. So no renewal fees are payable on the patents of addition unless until the original patent is revoked or stopped and the patent of addition is converted into an independent patent, or the renewal fees then becomes payable for the remainder of the term of main patent. And it says no renewal fees are payable during any pendency of the application for that particular patent, because the renewal fees that becomes overdue. So if you don't pay, the renewal fees becomes overdue, and during the pendency time they are payable upon the sealing within 3 months of the recordal in the payment register or the patent register. Now coming to the working aspect, annual reports as to extent of working, that is by every patentee and licensee, are statutory requirements and must be submitted by the March, that is 31st of March every year for the previous year ending December 31st. And compulsory license and licensing of the right. It says on the failure of the work of patent within 3 years from the date of its sealing, that is date of its giving the grant or sealing, an interested party may file petition for grant of a compulsory license. So any interested party can go and file a petition for asking a compulsory license. And every patent for the invention relating to any method or process or for manufacture of any kind of substance or things intended, which is intended for mainly for the use or capable of being used as such as food, medicines or drugs, or in relating to any substances prepared or produced by any chemical process, then it says that is including alloys, optical glass, semiconductors, intermetallic compounds, all shall be deemed to be endorsed. That means it can be transferred. The license of the rights from the date of expiry of the 3 years from the date of sealing of the patent. And here comes the assignment. Assignment means the application must be filed on the prescribed form with the controller of the registration of assignments and any other documents creating an interest in the patent in order for them to be valid. And it says in order to be valid, an assignment must be recorded within 6 months from the date of that particular document, and a 6 months extension may also be obtained for assignment or for assigning. Coming to the license part, students, it says application must be filed with a prescribed form, that is with the control of the same registration of licenses or any other documents which is creating an interest on the patent in order for them to be valid, and a license must be recorded within 6 months from the date of document. The duration period, the patent lasts for 14 years from the date of filing complete specification, and it says if an application is filed with the provisional specification, temporary specification on 1st January 1989, a complete specification is filed on 1st January 1990, that is 12 months, I told you 1 year, and the duration is counted from January 1st 1990 only. And however, for the food, drug as well as for insecticide patents, the life is 7 years from the date of complete specification or 5 years from the date of sealing, whichever is shorter period. And restoration, it says application for restoration of a patent that lapses due to the non-payment of renewal fees must be made within 1 year of lapse. So if your patent rights is lapsed, then within 1 year you need to make the renewal for the non-payment of this lapse on the period. If any overdue annuity is not paid within the extension period, then 1 year period for seeking restoration commences from the date of recordal. Now coming to the infringement. Infringement means it can consist of taking away essential feature of a patent invention or using that claimed features of that particular patent rights which is already been granted and sealed, or copying patented substances, mechanical equivalents, or taking part in the invention. Now, while the patent is in force, use by the government for government purpose is not infringement, but such use must be paid on for terms to be agreed upon before or after use, and incidental or temporary use or use of research on use of foreign vessels do not constitute any kind of infringement. Now appeal lies in the High Court. So you can appeal in the High Court if there is any infringement, or it has been, that means if somebody uses your rights, or somebody is using your substances, or somebody using your, that is without taking a permission, they are using that particular patent rights, all that. So appeal must be lodged within 3 months from the decision of the controller. So here ends this particular unit, that is known as the intellectual property rights. So I had explained to you all the sessions regarding what is the intellectual property right, then what are the important 3 aspects, that is copyrights, trademarks, and we have the what is patent rights. So just we'll go see what are the important things we have explained and we have understood in this particular chapter, session 4 of unit 4. Now we understood here the documents required for filing an application. So it should be in triplicate, provisional specification has to be done in triplicate, then it should be followed by complete specification within 12 months, an extension period will be 15 months. Then if there is any drawing regarding the patent, it should be in triplicate if necessary. If any abstract related to that invention, even that should be in 3 copies triplicate. The information undertaking, listing of numbers, filing date, current status, all this of each foreign patent application is in duplicate. Then priority document, if anything is there, that can be put. Then declaration of the inventorship, followed by complete specification in case of conventional application, power of attorney, then fees, it should be paid in cash or local check or demand draft. Then application, that is where you need to apply, that is an appropriate office for filing an application. So it should be within that stipulated limits, the territorial limits, where the applicant or the first mentioned applicant, in case of joint applicants for the patent, normally resides or which has a domicile and a place of business, and wherein the place of invention actually originates. And if the applicant of the patent or party is proceeding having no business, place or domicile in India, the appropriate office will be according to the addresses of the service or India given by the applicant or party in the proceeding. So like this is examination and publication. So they'll thoroughly check all the application which is being submitted for getting the patent rights, and if there is any kind of objections, surely that will be communicated to the applicants or his agents. Then notice of opposition must be filed within 4 months of notification in the Gazette. An extension of 1 month is available but must be applied on or before expiry of initial 4 months period. So grant of or sealing of patents. So it must not be opposed or opposition in favor of, or it should be decided in favor of the applicant and is not refused the patent and is granted or sealed on payment of some prescribed fees within 6 months from the date of advertisement. However, the extendable can be for 3 months. And register of patents, it says the register of patents will be kept in the patent office and its branch offices, and patents register of patents it can be inspected, and it can also be, it is open for everyone, you can inspect it, and also if you want extra copy, you can take the extra copy by paying prescribed fees. And here the register of patents contains the full details of the patent, that is which includes the patent numbers, the names and address of the patentees, the notification and the assignment, renewals, then particulars in respect of proprietorship, that is ownership of the patent. Then rights of patentee. So the patent right will give a patentee the exclusive right to make or use that particular patent article or use of patented process, and he can prevent all others from making use of this patent process. And also the patentee has also right to assign the patent or grant license to another person or otherwise and deal with any kind of consideration in return. So this rights created by statutory circumstances by various conditions and limitations. And regarding renewal fees, it should be payable every year. The first renewal fees is payable for the 3rd year of the patent life and must be paid before the patent 2nd anniversary. And if the patent has not been issued within that stipulated period, the renewal fees may be accumulated. It goes on accumulating, adding on, and immediately paid, and it should be paid immediately after the patent is, once it is sealed or within that particular 3 months of the recordal in the register of the patents. And date of payments of renewal fees is measured from the date of patent, and 6 months grace is available to the extension fee. And no renewal fees are payable on the patentees of addition unless the original patent is revoked and the patent is of addition is converted into an independent patent. Renewal fees can then become payable on the remainder of the term of main patent, and no renewal fees are payable during the pendency of the application for a patent, and the renewal fees that becomes overdue during this pendency period are payable upon sealing within 3 months for the record of patents register. The working is, it says annual reports to the extent of working. Every patent and license a statutory requirement where it should be submitted by end of March 31st every year, and the previous year ending December 31st. So all this duration, license, I told you, restoration and infringement. So these are the important topics, students. So they can ask you what are the procedures for the patent rights, to obtain patent right, the procedure for registration of a patent right. Surely that will be asked for 10 or 15 marks. So study that, concentrate on that particular part because it has a weightage of 10 to 15 marks for the on point of exemption point of view. So I think you understood the topics which I covered to you today. This is the last session and the last topic in this particular unit. So that finishes the Intellectual Property Act. So in the next session, I will be starting with the next chapter, Unit 5. Okay. So it is related to the Competitive Act of 2000. Okay, students, let us see in the next session. Until then, take care. Have a nice day. Thank you, students.